The following podcast contains opinion and commentary protected by the First Amendment and fair use. It may also contain adult themes, adult concepts, and adult language not suitable for children. Viewer discretion is advised.
David Gingras, lawyer with flair, took on a case, thought he'd get somewhere. Laura Owens spun a tale so wild, claimed Clayton's twin said she bore his child. In the courtroom swing, they danced their plea, but the judge saw through that false decree. Paternity suit, it fell apart fast. Gingras' bold moves, they just couldn't last. 3 strikes, you're out. Gingras, hear the call. Your case struck out, watch it crumble and fall. Laura's lies, they swung and missed by a mile. 7 felonies down, no chance to restyle. Jazz it up, now the gavel's gonna slam. Gingras and Owens caught in their own jam. To the Arizona court he appealed with might, tried to turn the tide in the legal fight, but the Supreme Court said no, not today. Your claims don't hold, they're slipping away. Judge Mata's ruling, sharp like a knife, called out the fraud that cut through their stripe. No proof of twins, no truth in the claim. Gingras and Owens, they're losing the game. 3 strikes, you're out. Gingras, hear the call. Your case struck out, watch it crumble and fall. Laura's lies, they swung and missed by a mile. 7 felonies down, no chance to restyle. Jazz it up, now the gavel's gonna slam. Gingras and Owens caught in their own jam. Then the law came knocking with a heavy hand. 7 felony counts across the desert land. Fraud and perjury, tampering too, Laura's web of lies the jury saw through. Forged a sonogram, spun tales under oath. Her stories collapse, no room for their growth. Maricopa's justice, it don't play no games. Now Laura's indicted, carrying all the blame. Oh, the saxophone wails, for the truth been told. Gingras' swagger's faded, his case growing cold. Laura's dreams of victory, they're sinking in the sand. The law's got her number with the prosecuting hand. From the courtroom drama to the felony sting, this jazzy tale's got that bittersweet zing. 3 strikes, you're out. Gingras, hear the call. Your case struck out, watch it crumble and fall. Laura's lies, they swung and missed by a mile. 7 felonies down, no chance to restyle. Jazz it up, now the gavel's gonna slam. Gingras and Owens caught in their own jam. So let the trumpets cry, let the drums roll on. The tale of their downfall, forever it's sung. In the desert's heat, where the truth stands tall, Gingras and Owens, they took the big fall. Jazz it up now, let the story unfold. A courtroom caper in the key of bold.
Welcome everyone back to your favorite cubbyhole on the internet. We've got a quickie today. We have a discovery document that dropped earlier today from Coleswood Law Offices, the criminal representation for Laura Michelle Owens. And I think this is just a fairly standard boilerplate discovery request. There's really nothing terribly exciting here, but being a completionist, why not get it in? There were just a couple documents today that I thought were worth reading into our record of following this case. So this is, of course, State of Arizona versus Laura Michelle Owens. This is the defendant's rules for the 15.1 request for disclosure. And no, sorry, I can't make it bigger. We have beginning issues here as well. It's just the way some of these things are in the image files. You just can't make them bigger. It reads, counsel for the defense moves this court to order that the prosecutor make the following material and information within the prosecutor's control available for examination and reproduction. The defense further requests disclosure of these items within 30 days of arraignment. That's, of course, Arizona Criminal Rules of Procedure 15.1. The name, date of birth, addresses, and telephone number of all persons whom the prosecutor will call as witnesses, together with their written or recorded statements. 2. All statements of the defendant and of any co-defendant. 3. All existing and supplemental reports prepared by a law enforcement agency in connection with a particular crime with which the defendant is charged. 4. The names, addresses, and telephone number of experts who have personally examined a defendant or any evidence in the particular case, together with the results of physical examinations and of scientific tests, experiments, or comparisons that have been completed, including all written or recorded reports, results, or statements made regarding the case. 5. Copies of all medical and mental health records, papers, documents, photographs, or tangible objects which the prosecutor will use at trial or which were obtained from or purportedly belong to the defendant, including any tapes, statements, or conversations. 6. A list of all prior felony convictions of the defendant which the prosecutor will use at trial and documents by which the prosecutor intends to prove such priors. As far as we know, there isn't much prior for Laura. Unfortunately, a list of all prior acts of the defendant which the prosecutor will use to prove motive, intent, character, or knowledge, or otherwise use at trial. 8. All material or information which tends to mitigate or negate the defendant's guilt as to the offense charged, or which would tend to reduce defendant's punishment. 9. A copy of any electronic surveillance of any conversations to which the defendant was a party, including any jail tapes or surveillance of the defendant's residence or business. Ooh, that could be interesting. I wonder if that includes YouTube's. Could it be? 10. A copy of any search warrant and supporting affidavit executed in this case. 11. Whether or not the case has involved an informant, and if so, his identity and contact information regardless of whether the informant will be called to testify. I'm not sure that there was, and if there was, this is fairly standard boilerplate. I'm fairly certain, but again, I'm no legal genius, nor am I a practicing anybody in the legal profession. This is just a hunch that this is standard form for the Coleswood Law Office. It may be standard form for the state of Arizona, for all I know. Number 12 should be good. Any 911 calls existing at the time of the request related to this case. How about all the 911 calls had existed prior? And the ones that after she was raided. Oh my God. There could be quite a few 911 calls from the Casita and or the Lowens compound. Number 13, any CAD reports associated with this matter. 14, any completed written report statements or examination notes made by experts in connection with this case. 15, any recordings of interviews. Does that include the interviews by Dinkus the douche canoe?
The fucking douche canoe.
Oh, we hope it does. Number 16, last but not least. Well, maybe it is least. A list of all felony convictions and any misdemeanor convictions involving moral turpitude of all witnesses the state will call at trial, and a list of all felony convictions of all disclosed defense witnesses. The defense requests disclosure of prior felony convictions no later than 30 days from the filing of this request. Again, and that cites Arizona Rules of Criminal Procedure. All right, and that was submitted on June 10 by Coleswood Law Offices. So that's, this is just a little fun paper trail. There's really nothing exciting here. This is standard discovery, really, for criminal cases, I would suspect. And in our next document, also filed within a day, June 11, and stamped at 1:36 p.m. by the clerk of the Superior Court. And this is an order. This is an order from the court, and it is ordered authorizing and directing the clerk of the Superior Court to surrender the following into the temporary custody of the attorney for defendant. So this is more discovery stuff, and it's a transcript of the grand jury proceedings, which we know took place. We have not seen a transcript of the grand jury. We have some ideas since we saw the indictments that were signed off by the grand jury, but boy, wouldn't it be interesting to see a transcript of that? I wonder if that is public record. We do wonder. If it is, it'll appear. I'm sure that people are hot on the trail. And this was ordered that such things shall be returned to the clerk by the 18th of June, which has come and gone, of course. Today is the 25th. And not surprisingly, it would be ordered that in the event that the transcripts are not returned in a timely fashion, that the clerk shall notify the court so an order to show cause may be set and any other sanction. Counsel may be found responsible for the cost to reproduce transcripts at $2.50 a page. And that was signed by Judge Jennifer E. Green. So again, a quickie, but you know what? Just for giggles. Let's have a little bonus round, shall we? I happened to watch this just before hitting record, and this is Rich Lieberman, who's starting to figure out that things aren't quite what they seem with the family Owens, and perhaps what Ron and Jan Black are telling him may not quite be accurate. So this is his live from today, about 5 hours ago, according to this. The Ron Owens / Laura Owens legal drama is murkier than ever. Special report. So he goes on to start to question things, as of course most of us have since the beginning of this. And I'll give Rich a little bit of grace here that he's catching up. He's catching up. Ron and Jen, he knows them. He's friends with Ron. One big happy radio family. All those good things. He's starting to smell foul. And it's about time. Better late than never to the party, Rich. It's okay. Some people may be haranguing you to no end. And I know he says he's talked to Dave Neal in this. So conversations have been had with Mr. Lieberman. But of great interest to me, it wasn't so much what he said in here as he's starting to realize that things aren't adding up with everything that Jan and Ron are saying and what's going on with Laura and the GoFundMe and so on and so forth. But what was amusing was a comment down here from, I guess it's a couple hours ago now. I saw it when it's still fairly fresh. That's how slow I am in getting things done. And this is from someone who calls themselves Oswaldo Spalding 4128. And it says this. It's very entertaining. Is it Laura? Who could it be? I think it has probably come to the point where Ron has enough on-air comments by Rich to file a defamation lawsuit. I don't have my dun 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 music. Oh God, more things to put on the buttons. I don't know about his medical expenses. That is none of mine or Rich's. Apostrophe S, it's possessive. But the implications made by Rich are clear. Sure they are. Ironically, I believe it may be time for Ron, finally spelled correctly with 2 N's, to set up a GoFundMe page to help fund for the legal help he will need to sue Rich for defamation. Oh my goodness. Could it be Laura? I'll leave other people to investigate that. We've got other things to worry about rather than chasing ghosts that may or may not be Laura Owens, but it may be that the Maricopa County Attorney's Office would like to investigate whoever that is, just in case. Because if by any chance Rich Lieberman is a witness, then this could be witness tampering, and then Laura would be in violation of her bond. In which case, she would get the silver bracelets slapped upon her and hauled away. No more casita food for you, if that were to be the case. We don't know. I don't know. But it's fun to watch these stupid little things happen, isn't it? And of course, the usuals, including Lauren and Bruce, have already sort of chimed in, as have others, and I responded to someone here. If it is Laura, that would be naughty. Naughty, naughty, naughty. All right. That's enough fun for today. That's it. It's a shorty little evening delight for you. There's more coming up. I've got to get this whole thing with the country music career going, and I'm getting interrupted again with little filings. But that's the way it goes. We're keeping an eye on everything. So until our next one, stay tuned.
Why do we have to, every time Rachel says something, you're just like, oh, you're not listening. It's just like, I don't get it. She is listening. She's listening to every word you say. And she's presenting something, and then you come back and shake your head and sigh.
Okay. Anyway.
Submit to an interview. You can
Wow.
them.
Wow. Stop. Well, if you let me. We're moving on to the next question. We're not gonna get very far with that. So
They can prove that this is not the first time she's done it. But even if you disagree with me,
I felt like I was juggling a flaming chainsaw while having my leg bitten by a German Shepherd. Okay. All right. We're moving on to the next question.
what lawyer ever says that?
Well, you're welcome that I gave you that's such an easy way to roast me.
Allegations, you know it's a possibility you might not win something. We're talking about the
There's
appeal.
no chance you lost this appeal.
Yeah.
You will have this.
Rachel,
Here,
can I offer you like a cookie or something? What do you want me to say? What do you want me to
Not
say?
that. In our case, we like our case.
I shouldn't have said that. Can we move on? Okay.
Yeah.
Pull it up. These statutes were invoked.
Yeah. Okay. Hang on. You're getting. Okay.
But show me a case that says that, because your cases don't. I've read them all now. Just give me a quote from Holgate. Just give me a quote from Holgate that says.
Can you hang on? Can you hang on for just a second here? Okay. Lord. Okay. You are pretending. Wait. If you want me to stay on this, you need to let me have fair opportunity to answer. Okay.
David, of 58 minutes, you've probably talked for 42 of them. I mean, come on, man.
Okay, guys.
Hold on.
Let me.
I got the
Rachel.
case somewhere.
Oh,
There's
God.
only the Rule 11. Hold on. There's other authority. What was at issue in that case?
We got to move on. We got to move on from that.
So, is the whole point. Try to withdraw it. There were other issues before the court.
Oh, for God's sake. Okay, Steve, can we move on? Because we're not going to get.
And then you come back and shake your head and sigh.
I know,
Because
but
you don't have any authority to infringe his copy or whatever, that I interfered with his.
way before my time, way before I was there.
Way before you're there. Where are these children?
Okay, you ready?
Where are they, David? This is the one thing that I think everybody wants to know.
Okay,
She's still 6 months pregnant. Can I show my belly? How would she have a belly in November if she miscarried in July or August?
look.
It's still not appropriate for her to include that finding of fact. Where are the people? There were reasons that her findings would have been inadmissible.
My Lord. Steve, oh my God.
And then Rachel gets 5 to 10 seconds before you sigh.
Read the emails with Clayton, the emails with Greg, the text messages with Mike, 5 that it is, but something that purports to be.
Whatever.
If you would have won, I mean, obviously, if you would have won, you would have gloated too.
Here, sign something saying that you raped me, that Laura was pregnant. I don't know what that would be. I mean, she's been running around subpoenaing things, apparently.